Okay, perfect. So in today's session, what we are going to discuss are primarily these pointers, which you have it on the screen. First, we'll start with the background of the topic. Second is the ad hoc versus institutional arbitration. Third is interim relief. Fourth is appointment of arbitrators. And the fifth one is challenge to arbitrators. And the idea of this session is not to have a monologue from my side. If you have questions, please feel free to stop me and then we can have a conversation. Or if you want to write on the chat box, please feel free to write your questions on the chat box as we progress. So starting with the first point of my presentation, which is background to arbitration law within the Indian jurisdiction. If you look at the current law which applies to arbitration, it's the Arbitration and Conciliation Act 1996. Now, this law is not something which has been drafted from scratch from the Indian perspective. This law comes as an adoption of UNCITRAL Model Law International Commercial Arbitration Law 1985. And the conciliation part comes from the UNCITRAL Conciliation Rules 1980. However, there have been a lot of amendments in the Arbitration and Conciliation Act, but the main law is still 1996. Now, if you want to get an idea of what is that exactly we are going to look into within this session, is basically the procedures and how the tribunal is constituted. Just to give you in a nutshell how an arbitration proceedings look like, it starts with a notice of arbitration, and then there exists an appointment of arbitrator, and the procedure has to be followed in a way that equal treatment has to be given to the parties. Then commences the arbitration proceedings. Then there is statement of claim, statement of defense filed by the respondent. Meanwhile, if the parties want, they can also request for an interim relief. Then oral hearings and witness testimony. Then finally comes the point when the arbitral tribunal renders an award. After the award is rendered, then the losing party, the award debtor, may challenge the award, and after that, there exists the execution proceedings. Any questions so far in understanding the background of how the procedure looks like in an arbitration setup? Okay. I don't see a question, so which means we are good to go. Now, one of the landmark judgment which cannot be ignored at this juncture is the Balco case in 2012. Now, why this case is very important? Because in this case, the Supreme Court of India overruled the earlier position of Bhatia International versus bulk trading. Now, what was actually overruled? In 2002 case, the Supreme Court said that Part 1 of the Arbitration Act, which is the domestic arbitration, also applies to Part 2, which means even if the seat is outside India, still those awards can be challenged within the Indian jurisdiction. However, the Indian courts understood the mistake, and in 2012, they prospectively overruled and said Part 1 only applies to domestic arbitration and Part 2 applies to foreign arbitration, and you cannot set aside an award which is rendered outside India, which means if it's a foreign seat. Now, this was very important to understand the difference in between seat and venue. Now, if you look at the screen, there are two options: appellate jurisdiction and supervisory jurisdiction. The difference in between a seat court and a venue is this. Venue can be anything. For example, we are having this class on Google Meet. This is a venue. You can also have it in a physical classroom where it is actually happening, a geographical location or a digital location. That's the venue. It has no bearing on exactly what is the law applicable. However, a seat is the legal jurisdiction which law applies to the arbitration proceedings. So wherever the seat is, that courts get the supervisory jurisdiction to complement arbitration, but not to sit as an appellate body or an appellate jurisdiction of the arbitration proceeding. So this was the mean that a lot of times the people who have to decide on cases like this, where it becomes a very borderline cases, it becomes a big issue whether it's the appellate jurisdiction or supervisory jurisdiction. But if you look at the international arbitration practice, it is the supervisory jurisdiction which is entrusted to the courts, to the seat courts, and not the appellate jurisdiction. Any questions so far? Okay. Now, let's understand what do we mean by ad hoc versus institutional arbitration. Now, there are two ways of how arbitration is being done within the Indian jurisdiction. One is the ad hoc way, where it's fairly simple. Let's say the contract is in between A and B with respect to sale of mobile phones. Let's say it's 1 lakh mobile phones, which has to be sold to party B. Now, this becomes a dispute. There exists a contract, there exists an arbitration agreement. Now, how you do an arbitration? One is that you do it by appointing your own arbitrator, having your own set of rules, how you want to conduct the arbitration proceeding, and you have to book your venues. You have to make sure that all the administrative issues have to be decided and has to be paid, has to be planned, booked by the parties. That is precisely what we mean by ad hoc arbitration. However, if you want to go and have an institution which is going to administer your arbitration case, you want to go to an arbitration center which takes care of appointment of arbitrators if the parties are not able to appoint, which takes care of challenge to arbitrators, which provides for a set guidelines on how many days, within how many days you have to file the different set of documents. They will do all the bookings, they'll provide you the venues, they'll make sure that they send the reminders, they send you the digital links of all the docket, they take care of almost everything required for that arbitration hearing, that arbitration proceeding. That's institutional arbitration. Now, in ad hoc arbitration, because the parties have to do all of this, of course, it's lesser cost when it comes to ad hoc arbitration, but sometimes it's very problematic to actually come to a consensus over these administrative issues because the parties are already at a dispute stage. However, in institutional arbitration, everything is taken care by the institution, but it comes with a cost. Just give me a second. So in institutional arbitration, because you sign up to an institution, there exists an administrative fee which is charged by the institutional arbitration. Now, some of the famous ones with respect to institutional arbitration are the Singapore International Arbitration Center, International Chamber of Commerce in Paris, the Indian ones, which is Delhi International Arbitration Center or the Mumbai Center for International Arbitration, IAMC Hyderabad, are some of the examples, some of the leading institutional arbitrations within the Indian jurisdiction. Now, why is it a thing that internationally institutional arbitration is more preferred? Within the Indian setup, it's different. It's more ad hoc arbitrations. According to a Khaitan survey, it also provides that the stakeholders still opt for 55% people opted for ad hoc arbitration and only 45% people opted for institutional arbitration. Within the Indian setup, it's also majority of ad hoc arbitrations and less institutional arbitration. But why is it the case that internationally it's institutional arbitration which is leading the majority number of arbitrations? Because in the institutional arbitration, it provides for a detailed guidelines. It also provides for scrutiny of awards. It also has a very tight timeline and it has a better enforceability of those awards. Now, this ad hoc versus institutional debate is also addressed within several reports. And one of the amendments in 2019, they encouraged institutional arbitration in India. And the parliament came up with the introduction of Arbitration Council of India, One of their functions is to promote institutional arbitration. If we look at the Draft Arbitration and Conciliation Amendment Bill 2024, Section 2C, which is introduced in this bill, provides for a definition of arbitration institution. And Section 9A provides for an introduction of emergency arbitrator. Now, these two give an example of the parliament has come up with a draft bill which provides for a definition and they want to promote institutional arbitration. So now let's move to the next part of my presentation, which is on interim relief. Now, let's understand what is an interim relief. Interim relief is a temporary measure which is only for the time being. When you understand that you cannot wait for the final outcome of the case and you want some remedy to safeguard your interest in that case, it's called the interim relief. So I see a question on the chat box. 2024 bill is not enforced yet. No, it's just a draft bill. It's not even a bill. So if it has to be enforced, it has to become an act. And as we discuss this now, it's still a draft bill. First, the stage is draft bill, then a bill, then an act. It's not enforceable. It's just that it's already there from 2024. So I make sure that I have to also include those things which may be helpful for you to understand why are we talking too much about institutional arbitration in India. So now let's come back to interim relief. Now, interim relief is a temporary measure which is going to preserve the rights and interests of the parties involved in the arbitration. It helps in preservation of assets, sometimes securing evidence, injunctions, specific performance. If there is no interim measure in arbitration case, what will happen? Even if you win an arbitration, technically there'll be nothing left to actually pursue from that arbitration. That's why interim relief is very important for us to understand. Now, how interim relief is working out within the Indian law. There are two specific sections which we need to understand. One is Section 9, which provides for interim relief by the court. Section 17 provides for interim relief by the arbitral tribunal. Also, there is a related amendment, which is in 2015, which provides that if an order of interim relief has been granted by a court prior to the constitution of the arbitral tribunal, parties are required to initiate arbitration within a period of 90 days. Once the arbitration proceedings have commenced, the parties have to necessarily go to the arbitral tribunal unless until the party prove the existence of circumstances that make a relief granted by an arbitral tribunal inefficacious. So the general rule is if the arbitral tribunal is not in place, you go to court. But if the arbitral tribunal is already constituted, you have to mandatorily go to the arbitral tribunal. Only exception is if their remedy is not going to help you out. And the powers of giving an interim measure by the arbitral tribunal under Section 70, as well as the power of the court under Section 9, are on the same level. Now, what are the courts that can give you interim relief?
Hi, sir. I had a question.
Yes.
So suppose you get an interim relief granted by a court prior to the constitution of an arbitral tribunal. Does the tribunal have to ratify that relief, or does it continue for a specific time period? How does the interim relief work in this instance?
So this interim relief is only applicable till the point of time arbitral tribunal doesn't decide otherwise. The arbitral tribunal has all the rights to render another interim relief. They can stop that relief, they can validate that relief, they can also modify it. So the interim relief granted by the court only applies till the time the arbitral tribunal is not constituted. Let's say if the arbitral tribunal wants to make sure that the same relief is continued till the final outcome, that can also happen. So to understand this, you need to understand once the arbitral tribunal is constituted, arbitral tribunal gets all the jurisdiction to decide anything with that arbitration, including the interim relief. So they have all the powers to look into it, modify it, stop that relief, or continue that relief. They will decide it.
All right. Thank you so much.
And this is the reason why within the law it is said that the interim relief, if it is granted by the court, you have to make sure that within 90 days the arbitration proceedings start. You cannot treat that interim measure as the end resolution of the dispute. So that's the idea behind this 90 days time limit.
So,
Now,
suppose the interim relief, you have 90 days to start the proceedings, but the proceedings don't start. Does the interim relief expire naturally then?
no, technically, there is a procedure of condonation also, but think of this practically. If, let's say, it's been 100 days and there is no tribunal constituted, does that mean that on 91st day there is no interim relief? In that case, technically, you should go back to that court to get a remedy, to get a continuation. But unless until there is an order of the court or order by the arbitral tribunal, it will be deemed to be applicable. That
Okay.
interim relief. Think of this with an example. Let's say that I have to sell you 1 lakh iPhone 17 Pro Max. You get an interim relief that Akash has to keep that 17 Pro Max. And think of this, that this is, one day after the launch of iPhone 17 Pro Max in India. I'm the exclusive seller of this, and you're the exclusive buyer from me. And it's not a small amount. It's, let's say, 1 lakh mobile phones. Now, let's say you get an interim relief that Akash has to preserve this 1 lakh mobile phones. He cannot sell it to anyone else. You get this remedy, interim relief by the court. The tribunal is not constituted. Let's say till 90 days it is applicable. Do you think on 91st day I can sell it to anyone else and say that because it's 91st day it's not applicable? Think of this. Unless until the court says that now this interim relief is all over and we are not going to continue it, or the arbitral tribunal modify it is going to be deemed to be applicable. Because otherwise, if the assets are still not, if the subject matter of the dispute is not intact, then what will we do with the arbitration? So you have to make sure that you understand that the subject matter has to sustain. Otherwise, there is no use of having an arbitration or even for that matter litigation. Did I
Yes.
answer your question?
Perfect. Thank you so much.
Okay. Now, which code section 21E provides the answer for which codes can give the interim measures? And for granting an interim measure, you have to understand this, that if you're talking about a foreign arbitration, let's say the arbitration is in between an Indian party and a Singaporean party. In the same example, let's say the mobile phone example, it's Indian party versus Singaporean party. And what happens is you have to get an interim measure, which is more like freezing the bank accounts of a person of a company in Delhi. Do you actually think it's better to go to Singaporean courts, get an interim measure application, then come to Delhi courts to enforce it? Or do you think it's better to come to Delhi courts, which is having the jurisdiction over the banks and getting an interim measure right here in Delhi so that you can do an easy enforcement? So wherever you want that interim measure to be enforced, it's better that you can directly go to that particular jurisdiction. Now, all of this is something which is very much related to where the parties come from, which courts have the jurisdiction, which is the remedy that you are seeking out in terms of interim measure. Now, the Kerala High Court in M. Ashraf decided that when an application is made before a court under Section 9(1) of the Act, after the award is made but yet to be enforced, the court has the power to grant interim measure as the tribunal is conscious official. Even after the award, you can still seek for an interim measure. Now, what are the threshold to grant interim measure? Technically, it's 3, which is prima facie case, balance of convenience, and irreparable injury. Now, there is no standard prescribed under Section 9. And if you look at the judgment, some of the judgments say that You can take some guidance from the CPC, the orders given on the slide, but some of them say that CPC is not directly applicable. It is not mandatory to be applicable because there is just a section of the Act which provides CPC and Indian Evidence Act is not applicable. However, the guidance comes from the three requirements, which is also something we see within the CPC interim, within the CPC law. Now, in one of the case, SR House versus ArcelorMittal, the division bench of the Supreme Court held that CPC is not applicable. However, the court also noted that the court is not bound by the same when faced with the. They said that the principles of CPC are, of course, going to be helpful, but the court is not bound to follow CPC to grant an interim measure, which means that the requirements is something, the principle is something which we can follow. Now, interim measures by arbitral tribunal is provided within section 70. And there are certain reliefs which can be granted, for example, securing the amount in dispute, detention or preservation or inspection of any property, interim injunctions or the appointment of a receiver. An arbitral tribunal cannot grant an interim measure against a third party. Now, in this case, you have to move to a court because only a court can help you with an interim measure against a third party. Any questions so far? Okay. Now, looking at the threshold for grant of interim measure within the international commercial arbitration, if we follow Gary Vaughan's book, where he says that the standards applied by national courts have no bearing on the arbitral tribunals while granting interim measure, which means that the domestic laws, the civil procedures of the nation has no bearing on how the arbitral tribunal is going to grant an interim measure, and they do not have to follow the domestic laws. Now, in simple words, there are three requirements in according to his book, which says that irreparable harm, urgency, and no prejudgment on the merits of the case. If these three requirements are met, then Bond says that there needs to be an interim measure for the party requesting for it. Now, how we enforce the tribunal ordered interim measure? The amendment to Section 17 of the Act has now clarified that an order of the tribunal would be enforceable like an order of the court when it comes to Section 9 interim measure. Non-compliance of an arbitral tribunal can also amount to contempt during the course of the arbitration, and this comes from a judgment called Alka Chandeville. Now, there is this new thing, not new per se, it's actually internationally, it's an old thing, but fairly new in India, which is emergency arbitration. Now, just to make sure that we understand what an emergency arbitration looks like, let's check one of the centers, Stockholm Chamber of Commerce Emergency Arbitration Rules. Now, emergency arbitration is something which is very quick. For example, appointment of the arbitrator happens within 24 hours. Once the arbitrator is appointed, within 5 days, the emergency arbitrator has to render an emergency arbitration award. And the rule also provides if the arbitration has not been initiated within 30 days of the emergency decision being issued, the decision will cease to be binding. This is a bit different than what we have discussed in the normal course of interim measure because this is an emergency arbitration. The same applies if the case has not been referred to an arbitration panel within 90 days. Any questions so far? Any questions? Okay, now let's look at how it is being treated within the Indian setup. If we look at the Indian law, the current law does not provide for emergency arbitration. However, the Indian arbitration scientists have rules which also includes for emergency arbitration, and the party may opt for emergency arbitration. Within the 246th Law Commission report, an emergency arbitrator definition was provided that it should be included within the act. Now, if we look at the MCIA Rule 14.6 or IMC Rules Schedule 1, the emergency arbitrator shall decide the claim for emergency relief as soon as possible, but no later than 14 days following the emergency arbitrator's appointment. So the timeline within the Indian scientists like MCIA or IMC Hyderabad is 14 days rule. Now, one of the landmark judgments in emergency arbitration is the Amazon case, where the Supreme Court held that emergency arbitration, even though it is not provided, well recognized within the Act, but there is nothing which stops from giving an effect to the enforceability of emergency arbitration. So, in this case, the court approved of the enforcement of an emergency arbitration award. And they said that the emergency arbitrator will be treated as arbitral tribunal under Section 21D. And that actually takes me back to the draft bill 2024, where it has been also provided that Section 9A has to be introduced, which provides for emergency arbitrator. So with this, we have covered 3 pointers which we had to discuss. Starting with the first one was background. The second one was with respect to the first one was with respect to the background. The second one was interim relief. Now we are moving to the next one, which is arbitrator appointment. Now, if we have to look at how the arbitral tribunal is constituted, the parties have to decide how they want to appoint the arbitrator. So now this freedom to decide the procedure is basically called party autonomy. Now, party autonomy is not something which flows from one party, it flows from both the parties, which means that there needs to be consent of both the parties on deciding the appointment procedure. However, there are certain guidelines which needs to be followed under the Indian Act. Section 10 provides for the number of arbitrators, even though the parties are free to decide the numbers, but the numbers have to be odd so that it cannot be a 50-50 ratio. So the parties decide the procedures, the parties decide the numbers, it has to be odd numbers. So Section 11 of the Act provides for the appointment of arbitrators, that the parties have to delineate a procedure, how they want to appoint it. And in case where the parties have no consent to appoint an arbitrator over one name, let's say it's a sole arbitrator, in that case, they can apply to the court and the court can decide on that, or the court may nominate a designated arbitration institution to nominate or appoint an arbitrator. It also provides, if it provides for 3 arbitrators and one party is nominated by party A, one arbitrator is nominated by party B, then both the appointed arbitrators may decide for the chair arbitrator. It is also very important to understand Section 12 read with 5th and 7th schedule. Now, Section 12 provides that 5th schedule provides for doubts over impartiality of the arbitrators. 7th schedule provides a list of scenarios which is ineligible to become an arbitrator. So Section 12 provides that the arbitrators have to disclose their, they have to disclose about the details which may rise to justifiable doubts regarding their impartiality and independence. Now, where do we get this idea of Schedule 5 and Schedule 7, which provides for a list of circumstances which can affect the conflict of interest of the arbitrators? The idea comes from the IBA guidelines on conflict of interest in international arbitration. The first time the guidelines came into picture was 2004. However, the last update of this rule happened in 2024. The IBA, International Bar Association, Association keeps on updating their rules. The last updating of this guidelines was 2024. Now, IBA is a soft law, which means that the parties have to include this within their arbitration agreement or the arbitration center rules. However, the Parliament of India has actually inserted the IBA guidelines through insertion of Schedule 5 and Schedule 7. Now, to understand Schedule 5 and 7, it is essential for us to understand what is IBA guidelines. Now, IBA guidelines provides for three lists, just like your traffic signals: red, orange, and green. Now, what is red list? Red list is the most serious, grave concerns over conflict of interest. In the red list, you have two divisions. The first one is non-waivable red list, which means that parties cannot waive it, even through an express agreement. For example, if the arbitrator has a financial interest within that case, even if the parties, even if the arbitrators have disclosed, the parties have accepted and waived that conflict, still it's an ineligible appointment. Waivable red list is where the parties may expressly waive it. For example, the arbitrator is related to one of the counsels representing to one of the parties. Orange list is something in the middle, which is more like a circumstance which may create doubts over independence and impartiality. For example, the same arbitrator has been appointed multiple times. If you look at the green list is a scenario which do not give an appearance of conflict. And to explain this, let's say that the arbitrator and the counsels sit in multiple conference panel discussions. That has nothing to do with conflict of interest. Now, if we look at Schedule 7 is non-waivable red list, which means if there is one of the circumstances mentioned within Schedule 7, if the arbitrator falls within that, it's an automatic disqualification and that person cannot be an arbitrator. However, Schedule 5 is a scenario which is raising doubts to independence, impartiality, but that person can be appointed as an arbitrator, so that needs to be heard and decided. Now, I see a question on the chat box. Can you please explain again what does it mean by supervisory and appellate jurisdiction? So supervisory jurisdiction means that the courts only tries to complement, to help and support the arbitration proceedings. Appellate jurisdiction is where, let's say you have a decision of the High Court and the Supreme Court sits as an appellate authority of the High Court, and the Supreme Court has all the powers to redecide on the same subject matter also. They have all the rights to modify it. However, in arbitration, it's a very limited grounds based on which the courts can interfere with the arbitral award. Now, I see another question. Limitation Act will enforce an emergency arbitration. If you look at the miscellaneous provisions of the Arbitration and Conciliation Act, it provides the answer for this, which says Limitation Act will only be applicable in cases where there is no time limit provided within the arbitration law. So if you look at the emergency arbitration rules of these institutions actually provide that after this number of days, whether it will be binding or whether it will not be binding. So there is a special provision already provided within the center rules, which is agreed by the parties, and therefore the Limitation Act is not applicable. Now with this, let's move to my final point, the fifth point. Starting first, we discussed the background. Then moving to the second one, we discussed the ad hoc versus institutional arbitration. Then moving to the third one, we discussed interim relief. Then moving to the fourth one, we discussed the appointment of arbitrator. And now we are going to touch upon the last portion of the presentation, which is challenge to arbitrators. And after I close this, all 5 pointers, then we open the floor for questions so that we can have a better discussion. Now, the fifth one is challenge to arbitrators. Section 13 of the Act provides that what is the procedure to challenge the arbitrators. So the general rule is that the parties decide their own procedure to challenge the arbitrator. If the parties have not opted for an institutional arbitration, then who decides the challenge? If the parties have decided to have an institutional arbitration, who decides the challenge? Or let's say if there is a question of automatic disqualification of Schedule 7, who decides the challenge? We'll come to this question in the next slide, but the overall procedure is governed within Section 13, which is provided within the Act. Section 13 also provides that there exists a timeline within which the parties have to challenge the arbitrator, which is 15 days from the date the tribunal's constitution or from the date when the party becomes aware of the circumstance which raises conflict. Now, who decides the challenge to the arbitrator? Ad hoc arbitration, it is decided by the arbitral tribunal. Institutional arbitration, majority of the institutional arbitration, especially if you look at majority of the leading arbitration centers, they have constituted a committee or a court which has expert members, leading arbitration practitioners, which are constituted. So let's say 3 members are, nominated to form a committee, and that committee actually looks into the challenge to the arbitrator. It is not the arbitrator themselves deciding on their challenge. Recently, Singapore International Arbitration Center has published, I think it's around 50 cases of SIAC where the arbitrator was challenged and the committee was constituted, and the redacted version of that decision to the challenge of the arbitrator is published online and it's publicly available. So this is how it is done internationally. And also courts can decide if there is an issue of, let's say, Schedule 7, which is de jure ineligibility, which means automatic disqualification because the person has a financial interest in the outcome of that particular arbitration case. Okay, so I see another question by Garima. Could you please share the presentation? Of course, you will get the presentation. The slides are made for you. Pretty much all my slides are available on open source. So that's not an issue. You will get the slides. And even if you are not able to get it, I will drop my contacts. You can always reach out to me. Okay. Now, this is how the challenge looks like. And this is one of the reasons also why institutional arbitration is better than ad hoc arbitration. Because in ad hoc arbitration, let's say it's me and Abhijit who are the parties, and it's Garima who is the sole arbitrator. Let's say if I get to know that Garima is a close relative of, Garima is somebody who is, who has worked for a substantial amount of time with Abhijit. In that case, if I have to challenge the arbitrator, I have to go to Garima herself because she's the arbitrator. And technically, she has the jurisdiction to hear this challenge to the arbitral tribunal. This is an ad hoc arbitration. Let's change the scenario. Let's say that we go to IMC Hyderabad. In this case, if IMC Hyderabad is our administering authority, what I have to do, I have to notify the center. The center will nominate a committee, and that committee will hear the challenge to the arbitrator Garima. This is how it looks like in an institutional arbitration, and these are the reasons why internationally people opt for institutional arbitration. Now, let's understand how this challenge to arbitrator looks like through some sort of case laws. Now, the first one, TRF Limited. In this case, the Supreme Court decided that if a person is ineligible to be an arbitrator, they cannot delegate the power of appointment to another. If you are yourself ineligible to be an arbitrator, you cannot delegate it to anyone else. The second case is Perkins, where the court held a person who has an interest in the outcome of the decision of the dispute must not have the power of appointing a sole arbitrator. In another case, Bharat Broadband, it was decided that Section 12, subsection 5, read with 7th schedule, which provides for a disqualification, and that disqualification is automatic, the parties cannot waive the conflict even by an express agreement, which means if a person has a financial interest and that person is appointed as an arbitrator, let's say party A challenged that arbitrator, in that case, party B cannot say that party A and B has signed a clause which provides for a waiver. Even if you have an expressed consent of the parties waiving it, still it is an invalid, ineligible arbitrator. In that case, the challenge will be successful. Now, here comes the last case, which is one of the most famous case with respect to challenge to arbitrators. It's usually called Core 2, but the full case name is Central Organization for Railway Electrification. So there was Core 1, and this is the final core, which is Core 2, 2024 Supreme Court, in which the Supreme Court held that panel-based selection is not per se valid. What does it mean? Let's say that if Central Organization for Railway Electrification is Party A, you are Party B. If core actually sends you a list of 5 arbitrators and they say that you have to decide within those 2 arbitrators, within those 5 arbitrators, you have to nominate the arbitrators. This panel-based selection is not per se invalid, which means that the section 12 and section 13, the idea of independence and impartiality has to be given due preference over any appointment of arbitrators. And in a nutshell, the Schedule 7, it's automatic disqualification. Schedule 5, there may be a chance of disqualification. So it is always better to do full disclosure of your conflict of interest as an arbitrator. Any questions so far?
Good evening, sir. I have a question.
Yes, please.
Hello. Sir, I have a question regarding the procedural framework in arbitration proceedings.
Yes.
Although the provision of the CPC are not strictly applicable to the arbitral proceeding, can it be said that the fundamental procedural principle and overall structure followed in the arbitration are substantially derived from the CPC, particularly in respect with the pleadings, evidence, and conduct of hearings?
Can you come again with your question?
Sir, my question is this, that although the provisions of CPC are not strictly applicable to the arbitration proceedings, can it be said that fundamental procedural principles are overall structure followed in the arbitration?
So I will say yes, you are right in saying that the guidance comes also from the principles within CPC, and majority of the Indian arbitrations have more effect of this because majority of the Indian arbitrators or a larger pool of arbitrators are also coming from one of the profession which is retired judges. So
Yes.
how they interpret interim measure, it's inherently there that of course even if it is not applicable, but the guidance comes from there. So you are right. But if somebody asks you whether CPC principles or the orders are binding, the answer is no.
Basically, it is not binding, but
Yes.
basic structure has been taken from CPC. We can say that.
Yes, of course. But we need to understand that unless until the parties has expressed consent to apply CPC or Indian Evidence Act, it is not applicable by default.
But sir, how a layman could know that what is CPC or what exactly an arbitration proceeding is? लेमन को थोड़ी पता होगा कि सीपीसी क्या है.
Why a layman has to understand this? I'm not able to follow you.
Basically,
Generally, layman will be represented by lawyers, no? So
Exactly.
lawyer will obviously know CPC, correct?
That's
and they will apply the CPC.
What sir is saying is, usually in any arbitration proceeding, there will be lawyers who represent the parties. They will be aware of CPC, obviously. So they can either consent for the CPC to be applicable or not.
Thank you, ma'am.
exactly.
Now I got that.
Now, understand this. Unless until you want to argue your own case, you don't need to know as a commercial party, you don't need to understand doctrine of separability or seat venue. But of course, your lawyer has to understand this. Otherwise, you will be in a problem. Now,
And even the arbitrator also has the discretion to decide on his own procedure as well.
exactly. But here's the thing. If you are into ad hoc arbitration, the procedure is also very problematic. If the
Yeah.
parties have decided a procedure, very good. Otherwise, the tribunal first has to decide a procedure for the tribunal, and only then the case will proceed.
Correct.
This is
Exactly.
another negative
Okay, sir.
of going for an ad hoc arbitration, and another positive for choosing institutional arbitration, because you have a set rules of procedure. But in an ad hoc, what is the rules applicable? The party, do you actually think that, let's say, me and Garima have a dispute with respect to the sale of 1 lakh phones? When we have a dispute already in between me and Garima, we'll sit down together and frame rules how we want to conduct the arbitration procedure? Not really. This is why I say that choosing an institution, even though it comes with a cost, but you have a set guidelines, you have a set rules, set procedure to be followed.
And you also save a lot on all these administrative issues and things like that. That's all taken care by the institution.
Yes, it's a lot of less stress, more money, but less stress. It's a piece of cake to go ahead with the procedure. You win the arbitration, you lose the arbitration, that's different. But at least you'll be able to follow a timeline and complete your arbitration procedure.
Correct.
Now, the last case, Core 2, in simple factual matrix, this was done that the Central Organization for Railway Electrification had a clause which used to provide that there exists a panel within which you have to select an arbitrator. Do you think it's fair to, what if I give you a list of 5 people and I say that you have to select one arbitrator from that? Do you think it's valid appointment?
No, sir.
This was essentially the question in the Supreme Court case of Core 2. And the Supreme Court said that this is not a valid appointment. This is an extension of an unilateral appointment, which means one case is the railway organization themselves appointing an arbitrator, which is called unilateral appointment, which is bad in law. They went to the next step where they said, even if an PSU or an organization creates a panel and asks the other party to select an arbitrator from that, even that is not valid in line with Section 12 and Section 13 of the Indian Act. Are we clear with this?
So you are saying that Supreme Court held that panel-based selection is not per se invalid. So
I think when I was typing, it's a typo error.
so that is why I was confused, because I have
No,
researched
please,
lot in this issue.
please
And
excuse my typo error in this.
Yes, because it says that it is per se invalid because you are restricting the number of selection.
You are right. It's a typo. What I'm saying is
Exactly.
something which you have to note, that panel-based selection, where one of the organization sends you a panel and then you can only choose an arbitrator from that. That's invalid. The Supreme Court said this, which is an extension. This case is an extension of an unilateral appointment. First, the question.
Because there is always a scenario of bias.
Yes, of course. And you need to understand the background of this. What used to happen, even it's happening now, unless until you go and challenge it. Of course, if you follow the arbitrators award, everything is valid. Now, what used to happen, the PSUs or these government companies had a contract which provided for panels, which is more like either they're working professionals or they're retired professionals. Even if there are 5 people retired from that organization who withdraw pensions from them, don't you think they have more affinity towards deciding in favor of those organizations? Now, all of this was discussed, and in these regard, the Supreme Court said that panel-based selection in a case like this, it's also invalid. And they said, even if it is unilateral, even if it is panel-based, the end goal of Section 12 and 13 is that an arbitrator has to be independent and impartial, which means that panel-based selection is not valid. The other party should also get an equal right and opportunity to appoint an arbitrator. You cannot override the appointment powers of the other party. Are we
Yeah,
clear?
because it has to be mutual, no? The appointment has to be mutual.
Yes, exactly. So I'll give you an example for this. How it works out in institutional arbitration is this. An institution has a list of people impaneled as an arbitrator. You can go to any institutional arbitration center, you'll see a list of arbitrators coming from a particular country, or maybe like 10, 15, 20 countries. You already have it on their websites. Now, once you raise a dispute to an arbitration center, based on the subject matter expertise, They give you a selected list of these can be the arbitrators. However, that is not binding. You can choose any arbitrator from the panel. You can choose any arbitrator outside. Only with the consent of the parties, the arbitrator is appointed. But what if party A and party B are not ready to consent to one arbitrator, to one name? Let's say party A says X, party B says Y. In that case, institutional arbitration centers has a rule which provides if the parties do not have a consent, we appoint the arbitrator, which saves a lot of time. But what happens in ad hoc arbitration? If the parties do not have a consent, a mutual consent on a particular name, then you have to go to court under section 11. And the courts, please don't think the courts are as quicker than the arbitration institution that within 24 to 72 hours your arbitrator is appointed. It doesn't happen that fast. So appointment of an arbitrator itself becomes a task in an ad hoc arbitration. Deciding the procedures is also a task within the ad hoc system. However, we need to also note that a lot of ad hoc arbitrations in India and also internationally, the parties do not make their own set of rules. So if you do not want to make prescribed rules for your own set of arbitration, what you can do is you can easily write in that arbitration agreement that the UNCITRAL rules will be applicable, and UNCITRAL rules are fairly decent. It's followed globally also. So UNCITRAL arbitration rules are used in majority of the ad hoc arbitration. Ombudsmen are not arbitration. Ombudsmen are very different. Every specific organization or a regulator can have their own set of ombudsmen. For example, banking sector has RBI ombudsman, banking ombudsman. Ombudsman is technically official. It's more like an industry-specific authority which can look into the grievances. That has nothing to do with arbitration. And with this, I come to the end of my presentation. And if we can open the floor for questions now, you have my contact email and also the QR right here on the screen. If I'm not able to answer your questions, or let's say you want to get some materials, please feel free to drop me a text. Any questions? Now I have covered what I had to present. So you can share your questions on the chat box, or if you want to unmute. Okay, I see a question. Do the arbitration contract have to beforehand decide that where will the parties go, the ad hoc or institutional arbitration? Technically, it should be decided while entering into the contract. Because if you haven't decided that, then you need to decide after the dispute has arisen. So for example, the contract which provides for a dispute resolution clause, which is any dispute arising out of this contract shall be resolved through arbitration under the aegis of MCIA Mumbai, which means if there is any issues afterwards, you have to notify MCIA, and MCIA rules will be applicable and everything is sorted. But what if you do not provide for MCIA, IAMC or ICC Paris? In that case, it's going to be ad hoc. Now, where the hearings will take place, who will appoint the arbitrators in case there is no mutual consent? In that case, you have to come back to the Arbitration and Conciliation Act 1996. And for every guidance or supervision, you have to go to the courts for that. And sometimes it also becomes a question that which courts? Because if the parties have not decided a seat. Now, this is the beauty of choosing an institutional arbitration. If you haven't provided for a seat, what's the seat? It's the location of that institutional arbitration. If MCIA, it's Mumbai. If IAMC, Hyderabad. If the parties don't choose it, by default, it is going to be the location of those centers. I see another question. As a final year student, I want to go for arbitration. What are the steps I should take now to have a good career in this field? Okay, so first thing first is that you have to read the basics of arbitration. Now, there are some books which you should follow. Of course, Gary Bond is one. 2 is Redfern Hunter. And any of the Indian textbook or Indian authors on arbitration should be fine to understand the recent laws on arbitration. Second is if you are a law student, then you have to expose yourself to ADR through ADR competitions. For example, ICC Paris or CDRC Vienna, the best ones, or arbitration competitions, arbitration moods, such as the best in the world is like WIS, which happens in Vienna, Hong Kong. Then there are FDI mood, then there is sports arbitration mood, then some of the leading Indian arbitration modes like NLIU Tankha or NLSTM Bangalore or GD Goenka arbitration mode. Fourth is something which is writing blogs or articles on issues related to arbitration. And fifth is fairly simple. You have to do internships where you can learn hands-on, practice of arbitration. I'm not saying that it has to be a particular firm, but a place where you can actually learn. Combining all of this with some sort of very reputed international courses, trainings, summer schools, winter schools like Paris Arbitration Academy or He Academy of International Law, or some other courses or upskilling which you should be doing to make sure that you can showcase through these things in your CV that you have tried to learn arbitration. Another question is, can the parties decide later after the dispute arises? Yes, party autonomy prevails. You can decide even after that. Another question is, what is the eligibility criteria for becoming an arbitrator under Indian law? Technically, there is no answer for this within the Indian law. The nearest answer to this is 2019 amendment, which provides that Arbitration Council of India has to be constituted. As we talk now, it is not constituted. It is going to be the arbitration regulator. One of their function is to make a list of eligibility, empanelment rules, what courses are recognized for that. So technically, as we talk now, there is no minimum eligibility. It's more like if you have a graduation degree in a particular field of law, or if you are a lawyer, you are eligible to become an arbitrator. You do not need to have a law degree to become an arbitrator. For example, if it's a construction dispute and you are an engineer who has a civil engineering background, you can also be an arbitrator. If you are a registered lawyer with the Bar Council of India, you can also become an arbitrator. The steps question I have already covered, so I'll go to the next question. I want to do LLM in ICAL Stockholm University. So what would you suggest India, Stockholm, and if India, where? Okay, so I will say internationally there are very good set of LLM. The most, I'll say, old in this was Queen Mary University of London. I think they started their international dispute resolution LLM around 1986. Then it came 2003, the Stockholm University ICAL LLM. In 2008, it's MITS Geneva. After that, there are a lot of other LLMs which are also very good. For example, Sciences Po, Humboldt University in Germany. Internationally, these are very good ones. And in India, there are also options. For example, I teach in the General Global Law School LLM area. So it's one of the leading LLM in arbitration in area. And then there are other options also which you may explore, but there are very limited law schools which offer this program because majority of the law schools do not have a specialized LLM area. So, and I'm not sure if the National Law Universities, any one of them has an LLM area. I think one of the nearest LLM is in NLU Sonipat, which I think they have a special LLM in area. So you have to make sure that you research into the Indian jurisdiction, you also do a research in the foreign LLMs, and then you do your own set of analysis that which one is going to help you based on your expectations and based, of course, on your merit, based on your financial budget. If we engage any institution for conducting arbitration, then what is the way forward for it? How much we have to pay to them? But it's fairly simple. You can go to any of the arbitration centers website and they provide for the administrative fee table, which provides if the dispute is in between, let's say, 10,000 to 1 crore, it's this much percentage. As you go up with the amount in dispute, the percentage of the total claim also goes up. So all of this is very transparent. It's not like ad hoc arbitration that nobody knows how much is paid to whom. In institutional rules, there is also a table for arbitrators fee, which is going to be applicable unless until the parties decide otherwise. Administrative fees all over the internet. You can go to their website and check.
Sir, so their selection of arbitrator will be also by the institution itself?
No, I never said that. It's very simple. Let's say you and I are two parties. Let's say it's a sole arbitrator. So we decide one name. For example, if you want to make Rahul our sole arbitrator, I propose Rahul's name and you say, yes, Rahul is very good, let's apply. Very good. If let's say I propose Rahul's name and you say, no, I don't want to, appoint Rahul as our sole arbitrator. In that case, we have to write to the institution and the institution will appoint an arbitrator. But the arbitrator is not appointed just like that. The arbitrator's name, the proposed name from the institution will come to us.
Yes, sir. That is what I want.
Will come to us, and also that arbitrator will share their own disclosure that whether that arbitrator has anything to do with me, my company, or any relations. The same has to be done disclosure with you also. And both of us will have access to that conflict of interest disclosure. Only after going through all of this process, that person's name will be approved for the appointment by the institution. And all of this happens very quickly in institutional arbitration. That's the reason why internationally it is more preferred.
Sir, so if we opt for institutional arbitration, then we cannot go to the court under Section 11 for appointment then?
Of course, yes. Understand this. What is party autonomy? Party autonomy is what you decide as both the parties. Once you decide to have an institutional arbitration, the
Yes, sir.
institution gets all of this supervision power. The courts do not have the power. Even if you go and file Section 11, the other side just have to say that institutional arbitration is already agreed and the courts will reject your claim.
Yeah, that is what I wanted to say.
Yes.
Like, if I'm going for institutional arbitration, then I have to get the arbitrator appointed through that institution only.
Yes.
I cannot go to the Section 11 petition in before competent.
Understand this. An arbitration has a positive and a negative obligation. What is a positive obligation? That you have to undergo arbitration. This is what Redfern Hunter says in his book. The negative obligation is you cannot move to the court. Similarly, when you have an institutional arbitration provided within your arbitration agreement, you have a positive obligation that you have to go to that center. The negative obligation is you cannot move to the courts with anything which is already governed under the center rules. Do you understand? So this is the rule.
So my question herein lies is, if I write that I'm going to Mumbai institution and therefore the parties don't agree to it and then they want to settle it in Delhi and they want to move it in Delhi. So when I write the name in the agreement, do I have to pay anything to them in Mumbai that I have mentioned your name in my agreement? Do I need to tell them at that moment?
Your scenario is very confusing. Are you saying that first you said that it's going to be an institutional arbitration within the contract?
I'll just break it up because I think I also got confused in two scenarios. My first scenario is, if I write the Bombay institution name in my agreement, do I need to let them know, notify them that I have mentioned your name in my agreement, and if there is a dispute between my parties, I will come to you, or we can simply mention their name?
You are not required to notify the center. But of course, if your contract has provided a center rules which is applicable, the moment one of the parties wants to initiate an arbitration, in that scenario, the party has to notify. Because otherwise, how will you initiate an arbitration?
Okay.
Yeah.
Okay. And my second scenario is, if I write Mumbai in the agreement, and then both
NCIA.
MCIA in the agreement, and then there's some Delhi institution which both the parties are comfortable reaching out, can they mutually shift to the other?
In that case, you have to write another agreement which says that both the parties hereby agree to go to Delhi International Arbitration Center and DIAC will be the administering authority. It's party autonomy. If both the parties are fine, of course you can. But this has to be done before you initiate any arbitration with MCI.
Okay, thank you, sir. And recently, when I was working with NHI in the arbitration matters, when in my previous years I used to work with them. So that time, the arbitrators were appointed through their panel. But recently, somebody told me that it is a set rule that Section 11 needs to be filed, and only High Court can appoint arbitrators from the High Court's panel. Is that right, or there's a difference in the scenario?
I think what you are saying is a very different scenario. It can never happen that the parties do not have a right to nominate or appoint an arbitrator. But if the parties do not have a consent over the name of the arbitrator and it's an ad hoc arbitration, only then you need to go to the court. I'll give you an example. Let's say Prerna and Akash are two parties. We propose Parth's name as arbitrator. Both of us are fine. Do we need to go to court? No. Let's say I propose Parth's name. Prerna says no. Parth is not fit to become an arbitrator in our case, and I reject this nomination by you. In that case, of course, we have to use section 11.
Okay, thank you.
Okay, let's look at the next question. I think the steps, how you have to initiate your arbitration practice, I have already covered. All of those applies. And of course, one thing which I think we should acknowledge and also focus is the role of networking. And you have to make sure that you also connect to the right people within the arbitration industry so that you, one, get to learn what is the new thing happening within the industry, you upskill, you get to know about the opportunities. And if you have to secure an appointment or if you have to get a case on arbitration, you have to make sure that you are also attached to the industry. Or even if you are teaching, if you are not attached to the industry, it's going to be very difficult for you to understand it. If you haven't done any arbitration, how will you talk about, rendering an interim relief, that you also need witnesses for the rendering of an interim award when it comes to attachment of property? It's not that the arbitrator can, you know, just render anything and then it's not required. In cases of attachment, there are some of the rules which has to be followed. Now, all of this is fairly discussed. Then another question is, can we intern under arbitration institutions like MCIA, IIM? Yes, all of them take interns. IIM is also one of the leading arbitration centers and they have interns. They also have a lot of accreditation and training programs. IICA also has a training program. All of this is fine. But technically, if you ask me which ones are going to be recognized by the courts, there is no rule for that because Arbitration Council of India is not constituted and nobody knows which trainings or which courses are recognized throughout the territory of India. But if you are doing it from the reputed ones like MCIA or IICA, IIM, IMC, DIAC, Nani Palkiwala Center, all of this are good ones. Okay, so with respect to internship, because a lot of you have asked me, there are different ways to explore arbitration internships. One is that you already know the lawyers working in that or the law firms. So I'm not going to discuss that. The last question is with respect to retired judges who do arbitrations. So they also hire arbitration associates. They also hire arbitration interns. So that is one way. The arbitration centers also have internships. For example, Asian International Arbitration Center in Kuala Lumpur, Malaysia. I did my last internship in my ninth semester for pretty much like around 2 months or 3 months. And it was also an internship which had a good honorarium for the interns. So you can also think of an international arbitration center where you want to do an internship. Then you can also do it with some of the leading international arbitration practitioners outside India. You can do a research assistantship with them. There are also a lot of professors who do a lot of arbitration. So there are so many ways to decide which one is something that you want to do. And how you explore is fairly simple. Now you have access to a lot of data on internet. If you are connected to the right people on LinkedIn, that will also give you some idea that which profile or which field that you want to pursue, whether it is something on construction arbitration or whether it is something with PSU's arbitration or whether it is something which you want to do with the arbitrators, the retired judges who are doing a lot of arbitrations. And there are different layers of this, and the data is also available on LinkedIn. You can easily understand the work profile of different individuals, and then you can reach out to them. Okay, so I think with this, we can, unless until you have more questions, we can end the session. IP matters, the answer lies in Vidya Drolia judgment, which Vidya Drolia in line with Booz Allen, which says that if it's a right in rem, then it's not arbitrable. If it's right in personam, it's arbitrable. Classic example, if it's a question of who owns the copyright of the book, that's not arbitrable. But if it's a question with respect to the royalty arising out of that book contract, that is something which is arbitrable. So it's very simple. In all of these courses, you have the website where they provide you all the details, where they ask you for the CV, the recommendation letters, and statement of interest, statement of scholarship. And you just have to use the portal or email them your applications, and then you get to share the results. This is how it's done for pretty much of all of these summer schools and winter schools. Okay, so if there are more questions, please feel free to drop me a text or an email, and I'll try to come back to you. Thank you very much.